214 calls. That's how many times my divorce lawyer called my ex-husband on his personal cell phone while he was supposed to be fighting for me. I sat in my new attorney's office, staring at the phone records printout, and I felt something I still don't have a word for. It wasn't anger. Not yet. It was more like realizing you've been performing in a play you didn't know you were in. Every meeting I'd had with David, every time he'd looked me in the eye and told me he was fighting for me, every time he'd made me feel guilty to keep me compliant, all of it was choreographed. He already knew how my case would end because he was writing the ending with my ex-husband. Some of those calls were at 2 a.m, 40 minutes, an hour, personal cell to personal cell, hidden, frequent, and constant for 6 straight months. And I'd paid this man $47,000. But let me start from the beginning. Before I get into the full story, if you're into stories like this, hit like and subscribe. We drop new ones every single day. The letter arrived on a Tuesday in January of 2025. A collections notice from Piedmont Legal Billing Services for an outstanding balance of $2,300 on case file WC 2024-0847. I had never heard of Piedmont Legal Billing Services, and the case file number wasn't mine. My divorce case through Whitmore and Callahan had been WC 2024-0291. I knew that number by heart. I'd written it on checks totaling nearly $47,000 over 8 months. So who was WC 0847? And why was a collections agency linking it to my name and social security number? I called Piedmont the next morning. After 20 minutes on hold, a representative told me the balance was for overflow administrative services on a family law matter handled by David Whitmore. She couldn't tell me more without a signed release from the firm, but she did say something that made me put my coffee down. The charges on 0847 had been accruing since March of 2024. 3 months before my divorce was even in its discovery phase. David had opened a second billing file under my identity, a shadow account I was never told about, never consented to, never signed for, running in parallel with the case I was already paying through the nose to fund. That night, I pulled every invoice David's office had ever sent me. I spread them across my kitchen table and started matching line items against my phone records, my calendar, my email. Within 2 hours, I had 17 billing entries for phone consultations I never had, 12 hours billed across 3 days for custody research that my friend Denise, a legal secretary, identified immediately as boilerplate template language copied from a standard form. Nobody spent 12 hours on that. And then the entry that stopped me cold. A 2-hour consultation charge dated October 3rd, 2024, 6 weeks after my divorce was already finalized, billed to my account for a case that no longer existed, coded to a general line item like someone had entered it by mistake and forgotten to clean it up. By 2 a.m, I had a spreadsheet with 31 discrepancies between my 2 case files and the sinking certainty that my divorce attorney had been stealing from me. But I didn't yet know that the billing fraud was the smallest thing David Whitmore had done. My name is Rachel. I'm not using a throwaway because the malpractice case settled last month, and there's nothing left to protect except my pride. And I gave up on that somewhere around the 3rd time I cried in a lawyer's office. In January of 2024, I hired David Whitmore of Whitmore and Callahan Family Law in Charlotte to represent me in my divorce. My husband, Nathan, had been having an affair. I found out through his phone buzzing on the nightstand while he was in the shower. 11 years of marriage, 2 kids, and it ended because of a text notification he forgot to silence. I found David through a coworker's recommendation. Good reviews, confident handshake. His retainer was $8,000, which I paid on the same day as my daughter Lily's 7th birthday. I remember sitting in his office signing documents while my mother took Lily to Chuck E. Cheese, thinking this is what my life is now, splitting myself between the person I need to be and the person I actually am. Here's the part I don't usually tell people, and the part that matters for understanding everything that came after. When David asked me during our first consultation what outcome I was hoping for, I told him I wanted to destroy Nathan. Those were my exact words. I want to destroy him. And David didn't flinch. He said he could work with that. Within the first month, David suggested we approach Nathan's employer. Nathan worked as a regional manager for a company with strict conduct policies, and David said if we could get documentation of the affair to HR, it would create leverage, pressure Nathan into conceding on custody and finances, rather than risk his career. I didn't hesitate. I was so angry that I would have agreed to almost anything, and David knew it. He drafted a letter. He never sent it. He used it as a threat through Nathan's attorney. But I authorized it. I looked at a strategy designed to potentially cost the father of my children his livelihood, and I signed off on it without blinking. I'm telling you this because what happened to me doesn't erase what I was willing to do. And because David didn't just use that letter to keep me quiet. He used it as an actual weapon when I tried to fight back. But I'll get to that. David was attentive at first. He told me I was in a strong position, primary caregiver, documented infidelity, solid financials. He said we could push for primary custody, the house, spousal support. I believed him because I needed to believe someone was on my side. But the case went wrong in ways that didn't make sense. Every motion David filed seemed to land flat. When we proposed a custody arrangement, Nathan's attorney countered with something that addressed every weakness before we'd even presented it. When I wanted to call my mother-in-law as a character witness for the affair, David told me it would backfire. Nathan's side had a rebuttal witness lined up before we'd even disclosed our witness list. When David suggested we subpoena Nathan's financial records from his side business, Nathan moved those assets to a new LLC the week before we filed. Every piece of strategy leaked out of our case like water through a screen door. I asked David how they kept anticipating us. He always had an answer. Nathan's attorney was experienced. Family law is a small community in Charlotte. These things happen, and every time I felt that flicker of suspicion, David would bring up the HR letter. Not directly. He'd say something like, "We need to be careful here, Rachel. We've already played some aggressive cards." He'd remind me that we weren't exactly operating from the moral high ground, and I'd feel that guilt settle back over me, and I'd stop asking questions. By June, my legal bills had crossed $30,000. I was borrowing from my parents. I'd taken a second job, doing medical billing from home, after putting the kids to bed, and we were losing. A case David himself had called a strong position was falling apart, and I kept thinking it was karmic payback for the threat against Nathan's job, for wanting to destroy someone instead of just wanting fairness. David started pushing me to settle in July. He said the judge wasn't likely to rule in my favor on the house. He said pursuing spousal support would antagonize Nathan and hurt my custody position. He told me sometimes the smart move is to take what's on the table and walk away with your dignity. Coming from the man who knew exactly how little dignity I had left, that was almost poetic. I was exhausted, broke, ashamed of the HR letter. So I did what you do when you're drowning. I grabbed the hand reaching for me without checking whose hand it was. The settlement was finalized on August 15th, 2024. Joint custody, alternating weeks. Nathan kept the house. I got a lump sum that sounded like money, until you realized the house was worth over $400,000, and we'd been paying the mortgage for 9 years. No spousal support. David's total bill came to just under $47,000, not counting the shadow account I didn't know existed. For the privilege of losing a case, he told me I should be winning. But here's what I didn't know yet. The thing that still makes me feel physically ill. Buried in the 50-page settlement agreement, in a section David had told me was standard boilerplate, was a mutual release clause. Both parties released all claims arising from or related to the dissolution proceedings, including claims against legal representatives involved therein. I signed away my right to sue my own attorney for anything he did during my case. David drafted that clause himself. He slid it into the document knowing I trusted him, knowing I was exhausted, knowing I was carrying guilt about the HR letter, knowing I would sign wherever he pointed because he was the one person in that room who was supposed to be looking out for me. And I did. I signed it. That clause would become the single most important sentence in my entire case. Not the phone records, not the billing fraud, not the shadow account. That one clause, and whether it could be broken. I found Carolyn Vega in February of 2025, former prosecutor who transitioned into family law with a reputation for going after other attorneys. I sat in her office with 2 boxes of records, every billing discrepancy highlighted and tabbed, the collections notice from Piedmont, the shadow case file number. But before I showed her anything, I told her about the HR letter, about the threat I'd authorized against Nathan, about the kind of client I'd been. I needed her to know the worst of me before I asked her to fight for me, because I'd spent 6 months wondering if what David did was partly my fault for being the kind of person who'd agree to that letter in the first place. She listened without changing expression. Then she said something I needed to hear more than I realized. Being angry during your divorce doesn't make you complicit in your attorney's fraud. You authorized an aggressive tactic that your lawyer recommended. That's a million miles from what he did to you. Carolyn subpoenaed David Whitmore's phone records the following week. And that brings us to the moment I told you about at the start. 214 calls and text messages between David's personal cell phone and Nathan's personal cell phone between February and August of 2024. Not through the law office line, not through proper legal channels, personal cell to personal cell. The records confirmed everything I'd been afraid to believe, and then some. Carolyn filed a formal complaint with the North Carolina State Bar and simultaneously moved to pursue malpractice. David's response was immediate, and this is where the HR letter stopped being a source of guilt and became a live weapon pointed at my head. Through his defense attorney, Paul Fenchurch, David filed a counter-motion arguing that I had engaged in sanctionable conduct by authorizing a threat designed to interfere with the opposing party's employment. He submitted the HR letter as an exhibit, along with a sworn statement claiming I had directed the entire strategy over his professional objections. He demanded my complaint be dismissed and referred me to the bar's own disciplinary committee for what he characterized as attempted economic coercion in a domestic proceeding. I read the filing in Carolyn's office, and my vision narrowed. He wasn't just defending himself. He was trying to turn the HR letter into proof that I was the bad actor, that anything he'd done was in response to my own misconduct. The letter I'd been carrying guilt over for a year was now being used as a legal weapon to bury me. Carolyn had anticipated this. She showed me that David's own billing records proved he had drafted the HR letter, researched the legal basis for it, billed me 6 hours to create it, and presented it to me as a recommended strategy. His own time entries contradicted his sworn statement line by line. The man had charged me to build the weapon he was now claiming I'd forced him to make. That was the moment the HR letter stopped being my shame and started being evidence of how David operated. He built tools to control his clients and then used those same tools against them when they pushed back. But standing between me and the malpractice suit was still the release clause David had buried in my settlement. When Carolyn first found it, she was honest with me in a way I've come to recognize as her defining trait. She said this wasn't a technicality she could wave away. It was a genuine legal barrier. David had been thorough. The language was broad, and I had signed it voluntarily, at least in the eyes of the law. Carolyn spent 3 weeks researching. She called me on a Tuesday evening while I was making mac and cheese for the kids. She walked me through it carefully. No dramatics, no silver bullets. She laid it out. If the release clause was itself a product of the fraud, if David embedded it in the settlement specifically to protect himself from the misconduct he was already committing, then the clause couldn't be enforced against me. The legal principle is called fraud vitiates consent. You cannot use fraud to shield yourself from the consequences of that same fraud. She'd found 3 North Carolina appellate decisions supporting the argument, not identical facts, but the same principle applied to analogous situations. She was careful not to oversell it. She said it hadn't been tested in exactly this context, but it was the only path through the wall David had built, and she intended to test it. This is the part of the story that I need people to understand, because it's the part that gets skipped over when people tell stories like mine. The legal mechanism, the thing that actually determines whether you get justice or get a good story you can never act on. Carolyn filed the motion to void the release clause. David's attorney fought it through 2 separate hearings. The arguments were technical and exhausting. Fenchurch argued the clause was standard industry language, found in 40% of negotiated settlements in Mecklenburg County. He produced 3 expert declarations from family law attorneys, saying the language was boilerplate. He argued that I had signed it with the assistance of counsel that the clause was mutual, that it benefited both parties. Carolyn's counterargument was precise. The counsel in question was the very person the clause was designed to protect. She showed that David had personally drafted the release language, that it wasn't pulled from a template, but written from scratch, with broader protective scope than the standard version Fenchurch was comparing it to, that David had inserted it in the fourth draft of the settlement, after 3 previous drafts contained no such clause, and that the fourth draft was created 2 days after one of the 2 a.m. phone calls with Nathan. She argued that having the Fox draft the henhouse's insurance policy didn't make the policy legitimate. The judge assigned to the case was Patricia Hollowell. After the second hearing, she took 3 weeks to issue her ruling. Judge Hollowell ruled in our favor. She wrote that allowing an attorney to insulate himself from future liability through instruments procured by the very misconduct at issue would fundamentally undermine the fiduciary duty upon which the legal profession depends. She noted specifically that the clause appeared only in the fourth draft, that its scope exceeded standard mutual release language, and that it was authored by the attorney it protected. The release clause was unenforceable. That ruling was the real turning point, not the phone records, not the billing fraud. The moment a judge looked at the legal architecture David had built to protect himself and said you cannot build a fortress out of the same bricks you used to commit the crime. Once the release was voided, the state bar took notice. Our complaint was elevated from the general queue to an expedited investigation. They subpoenaed David's office records, his email, his case files, everything. But the investigation needed more than documents. It needed someone from inside the firm. Maya Reeves had been David's paralegal until she left the firm in November of 2024. A few months after my divorce was finalized. Finding her took 2 weeks of LinkedIn searches and uncomfortable phone calls to former Whitmore and Callahan staff. Most people hung up when I said David's name. 2 told me they'd signed NDAs. 1 person finally gave me Maya's number with the caveat that she probably wouldn't talk to me either. She didn't. Not at first. When I called, she listened for about 30 seconds, said she couldn't help me, wished me well, and hung up. I called back the next day. She didn't answer. I left a voicemail saying I had David's phone records showing 214 calls to my ex-husband, and that I just needed 15 minutes. She texted back 3 hours later. 1 coffee, 15 minutes, and she wasn't promising anything. We met at a cafe in Noda. She was younger than I expected, 26, with the careful posture of someone who'd learned to make herself small in professional settings. She asked me what I wanted from her specifically. I told her I was looking for anyone who'd seen something wrong at the firm. Anything. And I told her if she hadn't, I'd finish my coffee and leave her alone. She was quiet for a long time. Then she asked to see the call dates. I spread the printout across the table. She ran her finger down the column and stopped on March 12th, March 28th, April 6th. She said those were nights. David asked her to leave the office early, told her to go home at 5, said he'd lock up. She remembered because he never let anyone leave early. She'd thought he was meeting someone. Then she told me she'd kept a log, not because she was brave or principled. She said that honestly, almost apologetically. She kept it because she was scared and didn't know what else to do. She was 26 years old, working for a named partner, and things didn't add up. Nathan coming to the office after hours, sometimes after 9 or 10 at night. David asking her to pull documents from my case file with no explanation, then telling her she could leave. Conversations she'd half heard through the thin wall between her workspace and David's office. She wrote down dates and times because the anxiety of knowing something was wrong and not being able to prove it was eating her alive. I asked why she hadn't come forward. She said something that stayed with me. Who was I going to tell? He was the lawyer. I was the girl who made copies and organized files. I didn't have proof. I had a feeling, and nobody takes a paralegal's feeling over a named partner's word. I asked if she'd share the log with Boer investigators. She didn't answer immediately. She asked whether David would know it came from her. I said I couldn't guarantee he wouldn't. She stared at her coffee for what felt like a full minute. Then she said she'd think about it. 3 days later, she called and said yes. The state bar's disciplinary hearing was held in September of 2025. This is where Maya's log did what phone records and billing statements alone couldn't do. It put a human chronology on the pattern and proved what was exchanged during those 214 calls. David's defense maintained that the calls were unauthorized settlement discussions. Unusual, Fenchurch admitted, but not prohibited under North Carolina's rules of professional conduct. The billing discrepancies were clerical errors. The shadow account was a firm bookkeeping mistake. The phone records proved contact, but contact alone wasn't proof of sabotage. Maya's log dismantled that defense entry by entry. Her log for March 12th noted David asking her to pull my custody evaluation documents at 4:15 p.m., then telling her to leave at 5. The phone records showed a 47-minute call between David and Nathan, beginning at 5:22 p.m. Nathan's attorney filed an amended custody counterproposal on March 14th that specifically addressed every point in my custody evaluation. Points that should have been confidential, attorney-client material. Her entry for April 6th documented David requesting my financial disclosure worksheets at 3:30 p.m. That evening, a 52-minute call to Nathan. The following Monday, Nathan transferred his side business assets to a new LLC. The timing was surgical. The panel cross-referenced 12 of Maya's log entries with the phone records and my case timeline. In 8 of those 12 instances, a call between David and Nathan was followed within 48 hours by a filing from Nathan's attorney that directly anticipated our strategy. Maya hadn't known what she was documenting at the time. She'd just written down what felt wrong, but laid end to end. Her notes created a causal chain that the phone records alone never could. The records proved when David and Nathan talked. Maya's log proved what David had in his hands when he picked up the phone. During the hearing, Fenchurch tried to discredit the log as self-serving hindsight. The panel chair asked Maya when she'd started it. She said March 8th, 2024, 5 months before my settlement was finalized, long before any complaint existed. She'd emailed entries to her personal account as she wrote them, and the email timestamps corroborated every date. There was no hindsight to argue. The panel also examined the shadow billing account. David claimed it was a standard overflow file used for administrative costs. Carolyn showed that the account had been created 3 days after David's first call to Nathan, and that several line items in the shadow file corresponded to time David spent on calls that appeared in the phone records. He had been billing me for the time he spent coordinating my case's sabotage. David Whitmore was disbarred, not suspended, not censured. Disbarred. His license to practice law in North Carolina was permanently revoked. His partner, Jim Callahan, issued a statement distancing himself and expressing shock. The firm dissolved within months. With the disbarment in hand, Carolyn moved to vacate my entire divorce settlement on the grounds of fraud and attorney misconduct. Every agreement I'd made, every concession, every hearing outcome that had been shaped by the fact that my own attorney was coordinating with the person I was divorcing. Judge Hollowell vacated the settlement and ordered new proceedings. In the renegotiated divorce, with Carolyn representing me, I got primary custody. I got spousal support. Nathan's side business, the one he'd hidden in that LLC, was factored into the distribution. The new terms were worth roughly $300,000 more than what I'd originally accepted. But I didn't get the house back. Nathan had refinanced during the year between settlements. The equity situation had changed. A tenant was living in the basement apartment he'd converted. We negotiated a larger cash distribution instead. The malpractice suit against David settled for less than we'd originally projected. His insurance had limits, and his personal assets were thinner than expected. Turns out a lawyer who bills phantom hours, runs shadow accounts, and coordinates with the opposing party isn't great at managing his own finances either. After Carolyn's fees, I paid back every dollar I'd borrowed from my parents and covered both rounds of legal costs. Here's where everyone is now. David Whitmore is no longer a liar. I don't know what he's doing, and I've made a conscious decision not to find out. For a while I checked. Then I asked myself what I was getting from it, and I couldn't answer, so I stopped. Nathan has the kids every other weekend. We communicate through a co-parenting app. It's functional, which is probably the most realistic thing to hope for. Carolyn Vega earned every dollar of her fee. She was honest with me when it would have been easier to let me hope, and she fought when the honest answer was that we might still lose. She was also the first person who treated the HR letter as what it actually was, a normal piece of aggressive legal strategy that David weaponized into a control mechanism, and then tried to weaponize again as a legal counterattack when I came after him. Watching his own billing records dismantle his sworn statement about that letter was the closest thing to satisfaction I felt during the entire process. Maya Reeves. I took her to lunch after everything was finalized. I told her that her log was what turned circumstantial phone records into a documented pattern of case sabotage. That without it, the bar panel might have accepted the unauthorized settlement discussion's defense, that the email timestamps on her entries were what killed Fenchurch's hindsight argument. She cried. She told me she'd spent over a year wondering if she'd made the right choice staying quiet while she was still at the firm, and another 6 months wondering if the log would matter to anyone. I think she'd been carrying that weight for a long time, and hearing that it mattered was what finally let her set it down. And me, I'm in a 3-bedroom apartment now, not the house. My kids each have their own room. I have primary custody and spousal support, which means I work 1 job instead of 2. Nobody in my life is lying to me about whose side they are on. I don't drive past the house anymore, not because I've achieved some enlightened state of acceptance. I rerouted my commute because it was making me late to work. Maybe that's what moving on actually looks like. Not a moment of peace, but a practical decision you make enough times that it becomes habit. Here's what I want people to take from this, not the emotional arc. The mechanism, the release clause was the lock. Fraud vitiate's consent was the key. The phone records were the evidence. Maya's log was the proof of what the evidence meant. David's own billing records for the HR letter were what destroyed his counterattack. Every piece mattered, and if any single one had been missing, I'd be sitting here with the full truth and no legal ability to act on it. If something about your case doesn't feel right, if your attorney's advice keeps steering you into worse positions, if you're losing a case you were told you should be winning, pull the thread. Check the bills. Look for charges on case, numbers you don't recognize. Request itemized statements, and match every entry against your own records. And if there's a clause in your settlement that your lawyer told you not to worry about, that's the clause you read first. Read every word, because the people who are betraying you built their escape route into the same document they told you to sign. Thanks for listening.